Hi, Judge Stevens. It looks like we have the attorney for the plaintiff and we have the court reporter, but we do not have the defendants yet.
Okay, thanks.
I don't know how long you would like me to wait before checking in. Oh, nope, we have them now, so I can bring them in when you're ready.
Okay, I'm ready then. This is case number 20-000211MZ, Stephen Carra and Robert Cushman, plaintiffs, versus Jocelyn, Benson, Jonathan Brader in their official capacities. Counsel are invited to enter the hearing room, and once there, to unmute and unveil and state their appearances for the record.
Judge, good morning. My name is Attorney Philip Ellison, and I'm appearing on behalf of the plaintiffs. Judge, the attorney arguing the motion is attempting to enter the room, and he's just texting me saying that he's not able to get in at the moment for some reason.
Okay, well, I'm sure that our technical person can hear him with that issue, and that will be managed shortly.
Very good, thank you.
And good morning or afternoon, Your Honor. This is Eric Rowe with the Michigan Department of Attorney General, appearing on behalf of Benson and Director Brader.
Matt Granda for plaintiffs, Your Honor.
Okay, we're here. This is a date and time set for a hearing on a request for injunctive relief. The case was filed on October 23rd. Service was made and a response was received. This is the date and time for your oral argument. On behalf of the plaintiff, what is it you would wish to say to the court?
At this point, Your Honor, I am very happy to report that the parties and the attorneys have been working very diligently this morning to try to reach a resolution, and I'm happy to report that we have.
I'm delighted to hear what it is.
I will read what my understanding of the substantive agreement is. There is, as indicated in the complaint, a written directive issued on October 16th, 2020 from defendants indicating the following. Challengers, poll watchers. While challengers and poll watchers have their rights and responsibilities established under law, election workers can strictly enforce requirements that they observe proper social distancing. Challengers and poll watchers are subject to the requirement in MDDHS order to use face coverings in enclosed places, unless exempt due to health reasons. Defendants will, as soon as possible, but no later than tomorrow, October 29th at 5 p.m., issue amended written guidance or a directive to clerks or local election officials saying something substantially as follows. Challengers, poll watchers. Challengers and poll watchers have certain rights and responsibilities established by Michigan election law. Challengers and poll watchers are required to wear masks that cover the nose and mouth to the extent medically able to do so consistent with the MDHHS order, and maintain social distancing when not performing their legal duties. Challengers and poll watchers should maintain at least 6 feet of distance between themselves and election workers and voters as reasonably possible. However, to the extent that it is necessary to temporarily stand in closer proximity to election workers, to have a challenge heard, to observe the poll book, or perform any other legal duty, challengers and poll watchers are permitted to do so, provided close personal interaction is as brief as possible. Once a challenge or necessary observation is complete, challengers and poll watchers should resume remaining 6 feet away from voters and poll workers. The parties would, following this hearing, also enter into a written agreement to that effect, incorporating the exact language as I just substantively outlined. That would be our resolution, Your Honor, that I think at this late hour encompasses everyone's interests.
On behalf of the defendants, would you concur that your colleague has accurately stated the terms of the proposed resolution?
And only to clarify, Your Honor, that we're not committing to the language, but in the substance of it. So there's going to, we were working in about 15 minutes before this hearing. So haste doesn't usually lead to the most clear instructions. So there may
Okay,
be
but
some further refinement. There will be some further refinement, but fundamentally, substantively, that is essentially what Director Brader said in the email we attached in our response. So there shouldn't be any problem.
Okay, so for my purposes, the key aspects of this agreement are that while the challengers are to be masked unless medically unable to do so, and to distance at 6 feet when not performing their tasks, they are permitted to approach poll workers in order to effectuate their work, doing so as briefly and efficiently as possible. That's generally what I think I've heard you say.
That is, in general terms, my understanding as well, Your Honor.
That is
All right.
correct on behalf of plaintiffs, Your Honor.
Well, thank you very much for working to resolve this amongst yourselves in the interest of the people of the state of Michigan. I will entertain then a motion, I should receive an order which would resolve this case. In a perfect world, I'd get it by tomorrow. However, I am more concerned that you get the directive out and amend the frequently asked questions for the election workers than I am about this court's docket. So if I at least get this matter resolved by order by election day, I'm happy. Thank you very much.
Understood. Thank you very much for your time this morning, Your Honor.
Thank
Thank
you.
you.
Take care. We are adjourned.